Performance issues are always believable. She wrote that in an email about a woman who had not made a single mistake in 14 months. Read it again. Performance issues are always believable. Not there were performance issues, not we documented problems. She wrote that they are believable as a strategy, as a tool, as the specific calculation of a person who has spent so long in rooms where she was never questioned that she stopped bothering to construct lies that could survive daylight. That sentence is why we are here today. The coffee on my desk had gone cold by the time I finished reading the discovery file. I do this sometimes. I read the files the night before when a case feels like it has more underneath it than the charge sheet suggests. Contract dispute, unpaid invoices, termination for cause, on paper routine. The kind of thing I resolve 14 times a month without removing my glasses. But there was something in the paper trail of this case that made me set down my cup and read it again from the beginning. Not the invoices, not the termination letter, which was boilerplate constructed in exactly the way boilerplate is constructed when the goal is to sound official without committing to anything verifiable. It was the timestamp. The contract termination email was sent at 11:47 p.m. on a Sunday, not a Monday morning, when a business decision might be made in the ordinary course of business, not in response to a documented incident or a formal complaint. At 11:47 p.m. on a Sunday, someone had sat down and written 4 lines ending 14 months of work, and done it at a time of night when the person most likely to receive that email would be asleep and least able to respond. In 38 years on this bench, I have learned to pay attention to timestamps. They tell you things that the words around them are trying to hide. The name on that email was Margot Delacroix. The name on the invoices that were never paid was Celestine Okafor. And what happened between those two names in the 8 months between that Sunday night email and the morning they sat across from each other in my courtroom is a study in something that has no formal legal term, but that I have watched operate in this city for decades. The assumption held by people with enough resources to sustain it that debt is optional when the person you owe it to cannot afford to make it expensive enough to matter. Celestine Okafor made it expensive. She made it expensive by being exactly what she had always been: meticulous, documented, and completely unwilling to accept a version of events she knew to be false. Before I tell you what happened in that courtroom, I want to tell you about Celestine Okafor. Not because victims require credentialing before they deserve justice. They do not. But because what was done to Celestine cannot be fully weighed without understanding the specific weight of what she had built and what it cost her to build it. She arrived in this country at 22 years old from Lagos, Nigeria, with an accounting degree from a university that nobody in this city had heard of, and a reference letter from a professor that she had folded and unfolded so many times during the flight over that the creases had become permanent. She did not arrive with connections. She did not arrive with capital. She arrived with a skill set, a standard, and the understanding, absorbed from watching her mother run a small trading business in Lagos for 20 years, that the only thing that actually protects you in business is your record, not your relationships, not your reputation, your record, the documented, verifiable, reproducible evidence that you do what you say you will do to the standard you said you would do it every time. She had built her bookkeeping firm on that principle over 21 years, 7 employees, 34 clients, a client retention rate that our industry peers described in the market analysis she had commissioned for her 10th anniversary in business as exceptional. She had also built it without a single investor, a single loan cosigner, or a single moment of assistance from anyone who owed her a favor. Everything was documented because everything had to be documented. When you do not have the luxury of being trusted automatically, you build a paper trail that makes trust unnecessary. That paper trail is what saved her. Margot Delacroix, wife of Thomas Delacroix, founder of Delacroix Logistics Group, a man whose net worth occupied the kind of territory where the difference between $40 and $50 million stops feeling meaningful, had hired Celestine's firm 18 months earlier through a referral from another client. The engagement covered the Delacroix family's personal financial accounts, not the corporate structure, which had its own internal team of CPAs whose salaries alone exceeded what Celestine's entire firm billed annually. The personal accounts, household operating funds, the family's charitable foundation disbursements, Margot's discretionary spending accounts, which ran to monthly figures Celestine had processed without comment because the numbers were not her business. Her job was accuracy, not judgment. For 14 months, she delivered accuracy. Every monthly report filed on time, every disbursement reconciled, every charitable contribution documented to the standard required by the Foundation's IRS filing obligations. 3 times during those 14 months, Celestine had flagged discrepancies in the household accounts, small ones, the kind that accumulate when someone is spending from multiple sources without tracking, and corrected them before they became problems. Margot Delacroix had never, not once in 14 months, sent a complaint, not an email, not a phone call, not a text message asking for clarification. Nothing that in any legal framework constituted documented dissatisfaction. On the 15th month, at 11:47 p.m. on a Sunday, she sent an email terminating the contract for cause and stating that no further payment was owed. $34,000, 2 months of contracted fees for work that had been completed, delivered, and received without objection. Celestine sent 3 invoices over the following 6 weeks. She received no response to any of them. Her attorneys sent a formal demand letter. The Delacroix legal team, a firm whose retainer Celestine's entire annual revenue could not have covered, responded in 2 paragraphs. Termination for cause, performance deficiencies, no payment owed. Here is what I want you to understand about that response from a legal standpoint. A termination for cause requires cause, not the assertion of cause, not the general impression of cause. Documented, specific, time-stamped cause. Written records of complaints made, corrections requested, deficiencies identified, created at the time they occurred, not reconstructed afterward when a payment dispute arrives. The Delacroix team had none of that. Because there was none of that, because there had been no performance deficiencies to document, what they had instead was the discovery file. And in the discovery file was the email. I want to walk you through what Exhibit 7 actually was, because I think the way it came to exist tells you something important about how people with significant resources think about people with fewer of them. 12 days before the termination email, Margot Delacroix had written to her personal assistant, a woman named Grace, who had worked for the family for 6 years and who, I noted, was not present in the courtroom, asking in those exact words, how do I end a contract without paying the remaining balance? Grace had responded with several options. She outlined the notice period under the contract terms, which would have required payment. She outlined a negotiated early termination, which would have required a settlement. And she outlined what she called the performance route, explaining that a documented termination for cause, if sustained, could potentially eliminate the outstanding balance obligation. Margot had written back 2 words, that one, and then in a separate message sent 4 minutes later, performance issues are always believable. I want you to consider the psychology of that sentence for a moment, because it is more revealing than anything that was said in my courtroom. Performance issues are always believable. She did not write, there were performance issues. She did not write, I believe there were performance issues. She wrote, that they are believable as a category, as a tool available to anyone with the confidence to deploy it. She had identified, through some combination of experience and observation, that claiming a service provider had performed poorly was a low-risk strategy, difficult to disprove, easy to assert, and sufficiently plausible to discourage a smaller party from spending money on litigation that might not pay out. What she had not accounted for was a woman who had spent 21 years building a paper trail, specifically because she had always understood that her word alone would never be enough. Celestine Okafor had receipts. She had always had receipts. Margot Delacroix arrived 18 minutes late on the morning of February 11th. There was no apology, no acknowledgement of the delay. She moved through the courtroom the way she moved through every room, with the particular ease of someone who has never arrived anywhere and found that things had started without her. Because things do not start without people like Margot Delacroix. Things wait. My courtroom had not waited. I had called the preliminary matters at 10 a.m. and proceeded through them. When she walked in at 10:18, I noted the time and said nothing. I have learned that silence, applied correctly, communicates more precisely than reprimand. She sat at the defendant's table, opened her handbag, placed her phone face down in front of her, a gesture I have seen from dozens of defendants who believe it signals cooperation while keeping the option of the phone visible, and began speaking quietly to her attorney, Preston Holt, without once looking at Celestine Okafor, who was sitting at the plaintiff's table 6 feet to her left. That, too, I noted. There is a specific kind of contempt that does not bother to perform itself. It simply omits the other person from its field of attention entirely. Not hostility, absence. Margot Delacroix had sat 6 feet from the woman she owed $34,000 to for 14 months of correct and careful work and had not looked at her once. Not a glance. Not the involuntary moment of eye contact that most people cannot suppress in close quarters. Celestine Okafor was, for Margot Delacroix, simply not in the room. That was the first thing I understood about this case. The second thing I understood came when Janet Kwan, Celestine's attorney, precise, fast, and entirely without unnecessary decoration, read Exhibit 7 into the record. The courtroom changed when she read those words. Not dramatically, the way a room changes when a window is opened and the air shifts. You feel it before you can name it. I looked at Margot Delacroix. She was looking at Preston Holt. Her expression had not moved. I said, "Mrs. Delacroix, I would like to give you the opportunity to respond to the claim directly." Preston Holt rose immediately. He spoke for 7 minutes. Contractual language, context, discovery scope, the totality of the business relationship. He was technically competent. He was also completely useless against a document his client had written herself in plain language, with clear intent, preserved in a server that had survived the discovery process intact. When he finished, I said, "Thank you, Mr. Holt." "Mrs. Delacroix, the email in Exhibit 7, did you write it?" She looked at me for the first time. I want to describe what I saw in that look carefully, because it is important for understanding what happened next. It was not nervousness. People who are nervous show it in their bodies, the slight forward lean, the hands that won't be still, the eyes that check the exits. Margot Delacroix was not nervous. She was something more difficult to work with than nervous. She was certain. Certain in the way that people are certain when they have occupied rooms like this one, rooms with authority and weight, and have always found that the room adjusted to them. Certain that this room would too. She said, "I'm sure my attorney has addressed all of that." I said, "He offered an interpretation of it. I'm asking whether you wrote it." She said, "I don't really see how." I said, "Mrs. Delacroix, did you write the email in Exhibit 7? And then she looked at me with the specific, mild irritation of someone who finds the repetition itself to be the imposition. And she said the 5 words that I will not forget. She said, I don't answer to you. I want to stop here and tell you what those 5 words actually cost her from a purely legal standpoint, because this is where the law becomes interesting. When a defendant in a civil proceeding refuses to answer a direct question from the bench about a document submitted into evidence, they do not simply preserve their position, they damage it. In the absence of an invocation of the Fifth Amendment, which applies to criminal proceedings and does not protect against civil liability, a refusal to respond creates what is called an adverse inference. The court is permitted, under the rules of evidence governing this jurisdiction, to infer that the answer would have been unfavorable to the person who refused to give it. She had not said she did not write the email. She had said she did not answer to me. Those are different sentences with different legal consequences. The first is a denial. The second is a declaration of status, and status in a courtroom belongs to the bench. I removed my glasses. 4 seconds of silence. Then I said, Mrs. Delacroix, this courtroom is not a restaurant, a charity gala, or a board meeting where your husband's title determines whose opinion carries weight. It is a court of law, and in a court of law, every person who sits in that chair answers to this bench, regardless of net worth, regardless of whose name is on the building, regardless of how long it has been since anyone in their life required them to answer for anything at all. I said, you will answer my question. Did you write the email in Exhibit 7? The silence that followed was not long, but it had a quality that I have only heard a handful of times in 38 years. The silence of a person discovering in real time that the floor is not where they thought it was. She said, yes, I said. And the phrase, performance issues are always believable, that is your language? A pause. She said, yes. I find that the termination for cause was manufactured. This finding is not based on inference or probability. It is based on a document written by the defendant in her own words, preserved in discovery, and confirmed in open court by her own testimony. Celestine Okafor worked for the Delacroix household for 14 months. Every report was accurate. Every deadline was met. Every discrepancy was flagged and corrected before it became a problem. She received not one documented complaint, not one written correction request, not one communication of any kind suggesting that her performance was deficient in any respect. What she received was a 4-line email at 11:47 p.m. on a Sunday, terminating her contract and withholding $34,000 she had earned. The defendant's own words tell this court why. Here is the judgment. Full outstanding contract balance, $34,000. This is not negotiated. This is the debt. Bad faith litigation damages, $18,500. This court does not regard the construction of a false termination for cause, the deliberate non-response to 3 invoices, and the deployment of senior legal counsel to bury a straightforward payment obligation under procedural motion as a good faith defense. It regards it as the deliberate use of resources to avoid a legitimate debt. That choice carries a cost. Full legal fees for the plaintiff. Celestine Okafor should not have had to spend money to recover money she had already earned. Total judgment, $61,700. Celestine Okafor gathered her documents with the same unhurried precision she had brought to 14 months of filing reports for a family that never once acknowledged the accuracy of her work. She did not look at Margot Delacroix on her way out. Not because she was angry. I do not think she was angry. I think she simply understood, in the way that people understand things they have always understood, that Margot Delacroix's attention had never been the point. The point was the work. The work was correct. The court had confirmed it. She walked out of my courtroom at 11:43 a.m. on a Tuesday morning, and I imagine she went back to her office and filed something that was due that afternoon. That is who she was. That is who she had always been. if you have ever done honest work and watched someone try to erase it, drop a comment right now. Tell me your city. Tell me what happened. Are you watching from Lagos? From London? From a city where the Margot Delacroix of the world have been getting away with exactly this for years, and no one made it expensive enough to matter until someone finally did. Tell me. I read every one. And if you know someone who needs to see this, someone fighting for what they are owed, someone who has been told their work was not good enough when they know it was, share this video with them right now. Not later, now. Subscribe to Courtroom Justice News. Every week, I bring you a case from this bench that I believe the world needs to hear. Not because it is dramatic, because it is true to something most of us still believe, even when the world makes that belief expensive. What you owe for honest work is not optional. The timestamp on that Sunday night email said 11:47 p.m. The timestamp on the judgment said $61,700. Both are permanent. Courtroom Justice News. The gavel doesn't lie.